Right now, I think Kinder Morgan's lawyers and Kinder Morgan itself is trying to play a legal manipulation type game. They're basically trying to get the provincial courts to impose a provincial order over a federal issue. And that in itself was obviously planned out and part of its strategy to put into question some kind of force order to remove protesters from Burnaby Mountain. And so this is opening up a big can of worms. It's like Kinder Morgan wanting to have their cake and eat it too. And protesters being there is symbolic enough to make sure that they want to make sure that, yeah, we want to stop work because these questions are still being dealt with on a federal level. So why is Kinder Morgan acting like a bully? And they're knowingly trying to use the province against the federal government to succeed in their own wishes to still continue on with what they're doing. And what makes it even more insulting is that they're a US-based firm within Canada using Canadian legal system to still try and impose its will, which was completely inappropriate. This is a First Nations issue. And when we're looking at all three levels of government, this being the biggest question of all, with who has rights and title over lands, especially in Vancouver or BC for the most part, it's unceded lands. And that needs to be a question that gets answered. And the recent Chilcotin Supreme Court case decision lends an ear and an issue to this matter. So when we're still talking about the three levels of government and looking at the province and the municipalities within those three levels of government, their authority being asserted needs to follow the federal capacity. It needs to follow a federal level. And so even in this case, when we're talking with our own First Nations people, Aboriginal, however you want to identify us as, these questions still need to be answered based on a sovereignty stance. Its rights protected within Section 35.1 of the Constitution, recent Chilcotin case. So obviously this is a whole new test area that needs to be dealt with within a federal court standing capacity. And to try and plug up holes from a municipal and provincial level, this isn't the place to do it, because they need to follow the federal guidelines. And federal guidelines clearly stipulate that now, because of the Constitution and because of the court case in itself from the Chilcotin decision, that there has to be full consent. And like I said, NEB is now dealing with things at hand when it's talking with Salish people over Kinder Morgan. It's still a question that's there. So why is Kinder Morgan still trying to act like a bully and impose their will on even surveying? It's inappropriate for them to be doing that. It's the wrong place, the wrong time, and so they're using the legal system to manipulate, provincial jurisdiction over federal jurisdiction. And ultimately, if it's coming down to NEB has to answer to the federal level, even through the Supreme Court in its own decisions in its own capacity. Even if there's legislation in play right now that can be considered, illegal, that goes in contradiction of court case decisions. Legislation can't and should not pass without it following those guidelines. It's law of the land. It's their own game. They need to follow their own game. The Tsleil-Waututh has already put its hat in the ring, so to speak, to start talking with the National Energy Board. That it's already under review. They're already following those steps, coming from an Indian Act elected, imposed Indian Act elected construct that's imposed on our people. One of the things that it's negating to fall back on is actual Aboriginal rights and title, and who are the rights and title holders of the land. It's not the imposed Indian Act Band Council structure, it's the true hereditary leaders of the land. And that in itself is not being heard. It's not being respected as much as it should be, if not even heard. So it's not even being respected at all.